Today, we are going to build a company power of attorney. With all our documents, you can see a sample, which will be a walkthrough, a checklist, the training video you're watching at the moment, and also some information before you even log in. It's all free. And it's also free to start building the document, and it's highly educational. So let us begin. I've got an account, so I've pressed start for free. I can pick up data from an old document, but I'm going to start the company power of attorney fresh. So what have we got here? Well, we're a law firm. We're an Australian law firm, and we're online. So we predominantly service other law firms, accountants and financial advisors. Other law firms generally white badge the documents they remove, leave consolidated from it. We've got hints on the right hand side. So what am I getting for my money? Another training video. Where's the lock and build button? We'll have a look at that later. But what is a company power of attorney? What is a company power of attorney? So we're really looking at the company giving power to a human being. I'm going to use the expression human rather than person. So it's a company giving a power of attorney to a human being, not an enduring power of attorney. That's a human giving power to a human. And it's not some sort of medical lifestyle power of attorney like a power of guardianship. Which is another human giving the right over your body to dial up the morphine or whatever. This is a company power of attorney. And it allows the company to do certain things. Sign on the company's behalf, carry out the company's tasks, look at the company's affairs. Well, doesn't the directors do that? The directors do that. Their job is to carry out the job of running the company. That's what a director does. Yes, I know. But if the company has a director and the director dies or you can't find them, then you've got no one running the company. So you should have a company power of attorney. Most accountants, lawyers and financial advisors, when they build a company on our law firm's website, will also build a number of other documents, shareholders agreement, three-generation testament trust will, and a company power of attorney, just in case. And that can sit dormant. So it might sit in the safe custody pack with an envelope marked, if I die or something happens, give this to John. The power of attorney is very good if someone dies. So if a director dies, the power of attorney will will allow the company to continue on. But if the company has no directors, so let's say that they're on an aeroplane mining company flying up to Europe, which has sadly happened, and the whole aeroplane goes down and every director's lost, the company can no longer operate until a director's appointed. And the company power of attorney can't do anything about that. So if you're a sole director company and the company goes down, you will need to, and if the banks find out, then the company power of attorneys of no value during the time when the company has no directors. In that case, the shareholder, or if the shareholder's dead, the executor will need to quickly appoint a new director. And as soon as that director's appointed, then the company power of attorney is back in business again. In order to get in order for the executor to call a general meeting of the shareholders, if the dead person was also, let's say the dead person was the sole shareholder as well, then your accountant would just pair up quick minutes, get them across, and the executor could sign it on the day of your death. And therefore you've got a director and you're back in business again. You generally don't need to go under probate to transfer proprietary limited company shares. So how does the company power of attorney operate? So here we go. The director has gone walkabout. So the company can't operate because the sole director is missing. The person holding the company power of attorney, which is called an attorney, will merely sign on behalf of the company. Is the company power of attorney signing on behalf of the director? No, of course not. The company power of attorney holds that job as for the benefit of the company, not the benefit of the shareholders or the directors. It's for the benefit of the company. It's a company power of attorney, not a human being power of attorney. Here's some examples of a person that went missing, real case. And let's have a look at the difference between a human power of attorney and a company power of attorney. So a human power of attorney is a human appointing another human, whether it be an enduring or a medical lifestyle power of guardianship. It doesn't protect the company. If the person dies that you've appointed, the human enduring or medical power of attorney ceases to exist. But if a director dies, the company power of attorney continues on. It's not affected by the death. It doesn't care that a human dies. A bit like Arnold Schwarzenegger's Terminator. It doesn't care. It's there to protect the company, doesn't deal with humans. Obviously, directors will sign the company will approve, as we'll see in a minute, will approve the company power of attorney and they'll sign it. But whether that director dies or not, it doesn't affect the validity of the company power of attorney. So let's have a look about the nature of a power of attorney, a company power of attorney as against a will. So what does it say here? So a company power of attorney and a last will and testament serve two different purposes. Again, a will is built on our website by a human being to deal with its assets when that human being dies. It's got nothing to do with the company. The assets in a company belong to the company, don't belong to the shareholders. Whereas a company power of attorney is the company itself allowing a human being to sign on behalf of the company. Oh, how wonderful. This is an image. I instructed the marketing division to do an Arnold Schwarzenegger type character protecting the company rather than protecting humans. And they've opted for a robot. I suppose it's very modern with artificial intelligence and what have you. But the story is important. A company power of attorney protects the company, not humans. Humans have their own enduring powers of attorneys, like Schwarzenegger's Terminator. Company power of attorney does not end when a human dies. It only ends when a company itself is wound up. So the company itself dies, it's wound up, or the company itself, not the human, but the company itself terminates the company power of attorney. The company giveth and the company taketh away. How wonderful. I want to save money, so I'd like to prepare this company power of attorney for 5 or 6 companies I own. You cannot do that at law. A company power of attorney is only to protect one company. It can't protect multiple companies. Well, what if the company, or 2 companies have the same shareholders and same director? You still can't. You need 2 separate power of attorneys. What about if one company is a subsidiary of another? The head company still has to produce its own power of attorney company power of attorney, and the subsidiary has to have its own company power of attorney. So let's fill this information in. So you see the red means that we're not happy. Our law firm's responsible for this document, and we're not happy having that blank. So Yuri, and this document's only will make it a proprietary limited company. An Australian company number has 9 numbers by law. Place of incorporation is New South Wales in this case, and the company started back in 25th of March. The company will not be used exclusively as a trustee of a self-managed super fund. So I won't tick that box, and I need the address. So I've got the address. I'm happy with that. And let's try and press next. I've got a green tick. Now that green tick's critically important, because if you don't get a green tick, it will go red, and we will not allow you to see the lock and build button. Oh, Professor Davies, I don't want this control. We own this document. We own the copyright. We're responsible as your lawyer for this document. So it has to be correct. And we will only let you get to the very end, well, and see the lock and build button if we are happy with the logic flow. Now, director. What is a director? Is the director the person you appoint, like the attorney? No, the director is the person that carries out the day-to-day management of the company. Is it the shareholder? No, the shareholder owns the shares in the company. The director carries out the duties. Maybe it's the same person, but a director is separate. So don't get confused between director, attorney, and shareholders. We want the name of one director. Now, this person here has 2 directors. Which one do they put in? We don't mind. We don't care which director you put in. We only need the name of a director so that we can address in the cover letter, because all our documents come with a cover letter explaining how the documents work. So let's get the name of Feek Smith Sis. He has a middle name, assuming Feek is a male's name, and you must put in middle names. So the director lives in Melbourne. At Melbourne Airport, goodness. So I am now happy with that as the person building the stock, and I see Legal Consolidated is also happy. There's another green tick. I'm doing very well at the moment. Now, I see there's some more hints here. Can't I just use a human enduring power of attorney from one of the directors? We've already dealt with that. Enduring power of attorney is a human to a human. It doesn't help. Oh, but Professor Davies, if I'm not here, then with the enduring power of attorney, the person I appoint, also called an attorney, sorry for the same language, but the person I appoint in my human enduring power of attorney will stand in my shoes, and I, as the director, means that the person I appoint in my enduring power of attorney stands in my shoes and can act as a director. No, they cannot. The role of a director is a personal right that must be carried out by that director. And I'll give you an example. I'm sick today. I'm sick, and I can't get into the office. But my wife holds a power of attorney for me, an enduring power of attorney, human to human. So can my wife turn up and carry out my duties at my job? Of course not. It's a personal obligation, an employee relationship. The same with a director. A director has to act as a director. It can't outsource that job of being a director. But isn't that the very nature of a company power of attorney? No, a company is appointing the attorney under a company power of attorney. A human being appoints enduring powers of attorneys. There's a hint on that. Fund managers and self-managed super funds. This is one of the main reasons why you would always build a company power of attorney, particularly if you've got, if it's acting as a trustee of a self-managed super fund, so a special purpose company. Now, in this instance, I hope they put my example in, because now, in this instance, under a self-managed super fund, for asset protection, you would probably just have one single director. But for a self-managed super fund, if you've got two members, they have to also be the two directors of the company. Now, in this case, the husband died. So two-director company, and the husband died. There's some life insurance in the self-managed super fund. The wife goes to the fund manager in Melbourne, the Rialto building, and says, I need the 2.3 bricks, the 2.3 million from life insurance. And the life insurance agency says, with absolute innocence, that's fine, but you have to have two directors sign. But the other director's my husband, and he's dead. Can't help you with that. So she couldn't get her life insurance out. Now, if she had a company power of attorney, she could have got her son or daughter or whoever she's appointed, a financial advisor, the accountant or the lawyer, whoever holds the power of attorney, the company power of attorney, to sign. So don't go into this world if you've got a company that's trustee of a self-managed super fund without a proper signed company power of attorney. Does the company look after family trust appointor? Goodness gracious. So there is a certain type of document you can build on our law firm's website, which is I'll make myself bigger. How about that? Handsome devil that I am. So with a family trust, particularly if it's got at-risk assets like property or businesses, you'll probably have a corporate trustee, a company, which you can build on our website. And that corporate trustee will do the day-to-day management of the family trust, but the appointer is in control. The appointer can hire and fire the trustee. So if the company went out of your control, the appointer can generally sack the trustee and put a new company in if it wanted to. Now, this is an interesting question, because what restrictions does the company power of attorney have? And it has a lot of restrictions. It doesn't have the widest power. And that's why you'll see all these strange page after page of powers in the legal consolidated power of attorney. If it's not in there, then the corporate power of attorney can't do it. The corporate power of attorney will deal with many issues of a trust relationship. So if the company can do it, generally the corporate trustee will be able to do it, but it can't act as a point as a separate entity. Perhaps the enduring power of attorney could deal with the appointer, but not the company power of attorney. Very interesting issues. One of my students is writing a doctoral thesis on that topic. I'm going to press, look, what about we No, I've got another green tick. Now, the attorney, now this is the lucky person that is going to, lucky human being, I've got to keep mentioning humans and companies. This is the lucky person. So it's Muriel May Bus. And she lives in Henchman Park in Queensland. Which is a very nice spot. So that's the attorney, that's the human being you are appointing. And I've got a green tick already. I wish I hadn't had green ticks. Maybe if I could just miss the bus. There we go. So I've got some red cap happening here, but I don't care. I'm going to go and wait, let me go to next. I'm infuriated that Consolidated won't give me the flexibility and whatever. I'm a control freak, as most of us are that run so-many super funds. But we've got to protect you as our client, so we can't let you fiddle with these things. It's important that it's strict there. But you can use your cursor and go straight to reference. But it's gone red, and you don't see any lock and build. So you'll have to go to the previous one. So back to attorney. Now, I am confused as to should the attorney be over 18 of sound mind? I know it's a pretty obvious question, but if your child's 17 and you appoint them now, it won't operate until they're 18. So that's a good question. Are directors liable for attorney's actions? Well, that's scary. Sorry for not making myself small there. Are directors liable for the attorney's actions? And yes, they are. So this is really interesting. So the nature of a director is really different to the nature of a person holding a company power of attorney. A director is responsible, and often if the company goes down, the directors go down with it if it goes insolvent or whatever. So just because the director has got some person holding a company power of attorney does not relinquish the poor director from their huge obligations. They're still liable. Now, that's a good question. What are the attorney's obligations? Because, if I'm liable as a director for the attorney's actions, I at least know what they meant to do. So, as you could guess, they must act in the best interest of the company, act honestly, and obviously if they don't, then they'll be liable together with the director. So the director's never going to escape from this. The director is always liable. Does the power of attorney give the attorney the same powers as the director? No. This question is wrong. The director has powers under a legislation, the second biggest piece of legislation in Australia after the Income Tax Assessment Act, and that is the Corporations Act. And the Corporation Act sets all the rules out for directors. But a company power of attorney is a creature of common law, of English law going over thousands of years, well, over 1,000 years. And the person holding the power of attorney is limited in their power to a clear direction under the company power of attorney. If the power is not in the company power of attorney, then the person holding the attorney can't do it. Where directors have almost all the powers of a human being. Well, directors have all the power of a human being, subject to the Corporations Act. So that's why when we go through the sample document, you'll see that you need to be very careful, because your bank or your titles office or someone else may say there's not enough power to do a certain thing you want to do. So check that. There's not unlimited company power of attorney. There's limits by both things you're allowed to do under Australian law and things that the company power of attorney allows you to do. So it's got two restrictions. We obviously draft the company power of attorney to be as wide as possible, but it's not infinite like a human. Well, humans aren't infinite, I suppose. There's certain things that a human's not allowed to do. Now, I want to restrict the power of attorney so it operates when I am dead or when I'm skiing in Japan. Good exchange rate with Japan at the moment. I want it to come into effect only if something happens. That's not possible. What you can do, because the power of attorney starts as soon as the company instructs the directors to sign it. As soon as the company power of attorney is signed, then it becomes operational. If you don't want it to be under the control of the attorney, then you merely keep it in a sealed envelope with the accountant or one of your trusted people. Another person that's trusted. Obviously, you trust your accountant. So you can't make the company power of attorney conditional upon anything. Does the word attorney mean a lawyer? This is a common question with enduring and medical lifestyle powers of guardianships as well. The term attorney is an American term for a legal practitioner. That's what I sit on the legal practice board, and we call lawyers legal practitioners. Obviously, it's a weird expression, but a lawyer. You are appointing in the enduring power of the company power of attorney a human being, which is called attorney. So it's not used in the sense of a lawyer. You're not appointing a lawyer, you're appointing an attorney who can be, or could be a lawyer, I suppose, but anyone over 18 years of age, of sound mind. The word attorney doesn't mean lawyer in this instance. I'm looking pretty good here. I've got everything I need. I'm going to press next. Still no lock and build, but I've got green ticks, so I'm pretty happy with that. Lawyer callback service. Can I change the reference name? What reference name? You will note that we give a name automatically being the name that we give it at Legal Consolidated. However, if you're an accountant, then you may well, and let's say this is Colin Buss, then we've got some accountants, lawyers and financial advisors have done hundreds of documents with us. They want to store the documents on our law firm's website because we store the documents indefinitely under a client name. So they could be Client Buss or Colin Buss, or could be their reference number. Obviously, if you're a mum and dad building this document, you just leave it as whatever you want to call it. Select this box, you want a business logo. No, remove Legal Consolidated's logo. Select a box, one of our lawyers' telephone. No, I don't need any of that. So I'm going to press next. Now hold your breath. See what happens? Whoa, the lock and build buttons has come up, which means, don't get excited because we've got to check the summary page. It means Legal Consolidated is now very happy with your document. Now you need to be happy with your spelling and the information you gave. So the company name is there, that's correct. 9 digits, that's correct. New South Wales, it's incorporated. The date of incorporation, yes, that's looking good. That address is correct. Now, if it's not correct, you just go back in and make the change. The attorneys, Muriel May Buss, reference. I am very excited. I'm now going to press lock and build. And only at this point am I required to pay for the document. If I pay for the document, it takes about 30 to 60 seconds for the document to be built by our website and be emailed to you and also be on the website. You can see it immediately. Success. My credit card was accepted and I see that I can now access the document. Very good. Congratulations. I'm not going to wait for it to be emailed to me because I'm just far too excited. So I'm going to access the document. So here's the document. There's my reference number. I might have 30 documents under that particular reference number. I've only got 2. One is an invoice for the use of the credit card, which is great, but I want to see the company power of attorney. It's a PDF. You cannot change this PDF. Oh, Professor Davies, I've got a PDF changer and I can change anything I want to. Yes, you can change the PDF, but then you will be getting a damaged document. We finished the document. We're responsible for it. If you change it, you will void the insurance that our law firm provides. Client professional privilege. And you get a document that will not work and we will not be responsible for it. Oh, but Professor Davies, I want to fiddle with it. Well, if you need to change it, let us know. We'll give you a voucher to update it. So there's the director. I can see now why it was there. Attached is the document, how to print it. I've got to download the PDF and I've got to print it off, and that's all wonderful. So this is the cover letter. We are now looking at the sample document. We just created it. Now it will be different for you because the documents are updated quite regularly, and different data would give them different results. But this is a sample of the document. How does a power of attorney operate? Is the power of attorney drafted as widely as possible? Yes, we've drafted as widely as possible. If your solicitor, accountant, financial advisor, banker needs to extend it, then email the law firm and we will consider updating our legal documents. But it's been a few years now since we've needed to expand the powers. But every time the Commonwealth Bank changes their head of legal, they often come up with a different wording. So we'll kowtow to your auditor of yourself and his super fund, or your head of compliance at a bank or whatever. But it's been a few years since we've needed to do that. Can I use a human enduring power of attorney for company matters? Well, we've already done that. So the answer is no. Interesting that the power of attorneys in Australia are all called enduring powers of attorneys, but in Victoria we call it an appointing medical treatment decision maker. You wonder who the government department or the administrator that came up with that mess of words. You just wonder what the government's doing. These power of attorneys and medical power of attorneys are unique to each state. Anyway. I'm not here to talk about enduring powers of attorneys. We're here to talk about company powers of attorneys. Do I lose my rights as the director? We've already done that. Limits on the company power of attorney. Well, we did discuss this and there was a hint on it, but there's a lot more data here. So a company power of attorney is a limited document, unlike a director. You cannot act except within the boundaries of this power of attorney. So if the power's not there, it cannot act. If there is no director for the company, the power of attorney is dormant until you get a director. But Professor Davies, isn't that the sole reason I spent a fortune with your law firm to get a power of attorney, a company power of attorney that deals with death of a director? Yes, and it does work if a director dies. But if there's no director left, then the company itself, under the Corporations Act, cannot act. Don't blame the company power of attorney. Nothing can happen. until the executor or the shareholders quickly do a minute to have a new meeting and appoint a new director, and then your company power of attorney is operational again. Person holding the power of attorney can't do personal things like sign an affidavit, and also certain things are not delegatable. I'm talking about employment and things like that, although a company doesn't employ. And also trust powers, fiduciary obligations could be limited, and cannot assign, the person holding the power of attorney, the attorney, cannot assign their privileges and rights. It's not really a privilege, or it's an obligation. Can't really give the obligation to someone else, and neither can the directors, of course. There's a very interesting court case in Queensland. The obligations of the attorneys, again, there's huge fiduciary obligations on the poor old attorney, big risks for them, but not as much risk as the director. The power of attorney has not been prepared to be lodged at the titles office in your home state. It's a national document, so it works in Darwin, or if you're in Burnie, or you're in Double Bay, or you're in Chewett Hill. It doesn't matter. It works Australia-wide, but it's not necessarily lodgeable with your local titles office. We're not property lawyers, so you need to check with your property lawyer on that, if you need to lodge it with the titles office. Generally, there's no stamp duty or transfer duty on a power of attorney, but obviously if you use it, it's used to transfer 1 million shares in BHP. There's obviously potential capital gains tax obligations on that transfer, but not generally on the company power of attorney itself. If you want to revoke a power of attorney, there's some advice on that. That's the last thing you want to do right now. I've just spent half an hour building it. But how do I sign the power of attorney? The signature must be in wet ink with a blue or black pen. Oh, Professor Davies, I'm pretty up to speed on signing by Zoom or signing by this. I don't care. I don't want you to electronically sign this document. It's fraught with danger. Oh, but I know you sign a lot of documents that, for example, a family trust deed. Recently, the law firm, a client signed it wasn't a client of ours, signed it electronically, but the banks only accept wet signatures for family trusts. Don't muck around, don't be exotic, don't look for trouble. Be demure, like me, and sign with a wet signature. The witness, never having been a sexual partner of the attorney. Goodness gracious me. So get someone that's independent as a witness. It's over 18, of sound mind, and Australian. Oh, but we're in Bali at the time. Well, try not to be exotic. I've just said be demure. Try not to sign documents in Bali. And there it is, signed up by the law firm. So now we've got minutes. So there's three things you're getting with the company power of attorney. You're getting the cover letter, you're getting the minutes, and you're getting the deed itself, which you're going to come to. So let's move to the dust cover, the front page of the company power of attorney. Yuri appointing Muriel May Buss, good. So you can see who the parties are in this. Where's the director? Where are the shareholders? Well, it's nothing to do with the shareholders. I've just explained to you, saw that picture of Arnold Schwarzenegger's robot. The company power of attorney protects the company. It's got nothing to do with humans. It doesn't care if a human dies. It's not party to the agreement. The attorney and the company are the parties to the agreement, not shareholders or your mum and dad or your directors. Let's move to the more interesting. So let's move to the more interesting powers. So this is what you're looking for in the power of attorney. Your solicitor, your accountant advisor, your auditor will want to look at this to see whether there's a power sufficient to deal with it. So We haven't, again, I said this hasn't been amended for a couple of years, as we haven't been asked to make any additional powers to it. Right, Professor Davies, it's far too wide for me. It's too wide. Well, then don't use it. Get a refund for it. If you don't want it to be wide, then don't use this document. But I tell you now, if you restrict the powers, it becomes very difficult to use the power of attorney. It's already difficult to use the company power of attorney because it is limited by these powers. So it can make, sign, seal, otherwise execute for the company. There's all the banking and lending institution requirements, and there's quite a bit of them, so let's move on. Power to employ people, deal with workplace foreign entity registrations. Now, the company power of attorney, as you'll see over and over again, is states that it works outside of Australia. So we're saying that in the power of attorney, but if you have a look at the covering letter, it says it may or may not work overseas. We don't know. We're an Australian law firm. Whereas the British would say Australian law firm. So if you need to use this company power of attorney outside of Oz, then you need to get a solicitor from that jurisdiction to check it. It doesn't necessarily work. It may, but we can't guarantee. We don't know. We don't work outside of Australia. We're Australian lawyers. So let's have a look at the next section of powers. Trusts and self-managed super funds are quite unique. So there are some peculiar and important clauses that go into this deed in case you ever need to use it, or in case your company, not you, you're a human. This doesn't help you. If your company needs to use it. Let's move to the next section. So there are certain important things that must go into all company power of attorneys, whether it's prepared by Legal Consolidated or anyone else. And that's firstly the power of severability. Now, what happens here is that in years to come, it might become illegal to grant for a power of attorney to have give the power to sign a software license or an IT contract. Pretty strange example, but let's say that's the case. And then if you put that in your agreement, which you have, then it will render void the whole of the company power of attorney. So that's not very good. So what clause 4 is saying is that where something is in the deed which offends a law, so that law may have been in Adelaide, South Australia, then this clause setting will just put a blue line through it, but the rest of the document is still valid. So it's called a severability clause or blue line principle. Critically important for company powers of attorneys. Let's have a look at the next section. So let's see who signs this document. So, and I've already said, you know who signs it. I've already told you, the company and the attorney, but let's have a look. So there's the sealing clause for the company. So it's pursuant to the Corps Act. This is signed as a deed, sealed, signed as a deed. A deed is a very peculiar type of document. Back when the Normans invaded in the Battle of Hastings, when the English were thrown out, the Normans took command. They had a ring. The nobles would have a ring, and whenever they did a document, they would seal it with their ring, and there'd be a bit of wax, and they'd seal it. It's called a seal. Well, that's the same here. Here's 1,000 years later, we still have a seal, but we sign it in this way. In fact, rather boring, really, because all you do is put signed as a deed. Lost a lot of that wax and what have you. Signed as a deed, and there it is for the company sealing clause. And then there's our friend, the attorney, Muriel May Buss, and she will sign in front of the witness. Well, my lawyer, Professor Davies, said we don't need to put occupation in of the witness. That's fine. You don't normally have to put an occupation. This is a very peculiar document, and you must follow exactly what we do. Again, don't look for trouble. Do exactly what our document's saying to do. So that is the power of a company power of attorney. Start building it. If you have any questions, please telephone the law firm and we can help you. We can help you, but start the building process first. It's highly educational. I said to one of my students, highly educational and entertaining. And he said, Professor Davies, it may be educational, but it's certainly not entertaining. And that student will probably get a C because he's been mean and rude to me. So enjoy the free resource of this law firm. Enjoy the free building process. Have a go first and then telephone us. We can help you review the answers and go through any further questions you have. But start the journey first. Enjoy.